and welcome to the Secrets of a B2B Marketer. This is a show where we talk about stories shared by B2B marketers. But today, we're making an exception. We've brought on the show someone who brings precious amount of knowledge about intellectual property, which is absolutely important to understand in context of B2B marketing. Let me welcome to the show Mr. Abhishek. Welcome to our show, Mr. Abhishek. I would like you to tell us a little bit about yourself.
Thank you. Thank you for inviting me and having me here to share some of the thoughts and experiences that I have sort of tried to accumulate over the 24 odd years of my practice as a lawyer. So I run a law firm by the name of TMT Law Practice. Really speaking, typically when you hear of a law firm, it is either the last name of a person and company or an associate and partners, etc. In my case, because I'm a first generation lawyer and because at the time that I set out on my own, there was a fair amount of buzz about the possibility of foreign law firms also entering the Indian market and a greater possibility of collaborations even within the community of Indian lawyers. So accordingly, I thought that it would be an impediment if I have my own name associated with the firm, because then either it would be addition of names or something like that. So that's why I chose TMT.
I thought the M in TMT stood for Malhotra.
So there is actually an interesting anecdote to that. One of my colleagues who was not working with me at that point in time but we were collaborating otherwise, and we were also intending to figure out whether something could work out. He suggested this particular term. So his initials were ending with T and mine with M. So TMT Law Practice would have been the Malhotra and that person's name, law practice. And then he'd rather we just be friends and continue our relationship otherwise. It just turned into TMT, which is also primarily the area where I was already advising clients on, which is technology, media, and telecommunications. So I started out as an IP lawyer. Very frankly, I did 1 year of criminal trial practice right out of law school. Because I wanted to check whether I was cut out for that. Realized fairly quickly that I wasn't. And since I was interested in IP, I went overseas to do an LLM in intellectual property rights, through an institution which at that point in time was number one on the East Coast in USA. I had the good fortune of also then working for a bit with Warner Brothers. I'm also qualified to practice in California. I took the California bar exam and I was fortunate enough to pass that. But that was 9/11 time, and therefore jobs were difficult to get. I went there on a scholarship, so I kind of cut my losses, came back home, joined one of the top boutique law firms for IP in the country, where I set up the IP practice. And finally in 2008 is when I exited from there with a view to set up my own practice. So that's a bit of a background by myself.
Well, that's a very interesting journey. I did not know that you've studied overseas. I'm sure that contributes towards IP understanding at a global level also, and we'll dig deeper as we go forward in our interview. But I would also like to understand your role within the company, given that I know that TMT is now a larger company and it's not just you. So what's the company role in terms of what all do you do, and specifically you in the company, what do you do?
Sure. So just one slight modification to what we are. As lawyers, we can't set up a company. We can only set up a firm. So it's either a firm under the Partnership Act or under the LLP Act. So either we can have a TMT Law Practice LLP or just TMT Law Practice. So we've currently chosen to be under the Partnership Act and in a regular firm. Second thing is that, even though I started out in 2008 when I set up this firm perhaps I thought that since I've been doing IP, I will continue to do that. But when you're on your own and you're trying to make ends meet, you're trying to pay off your bills, you don't say no to any work. Sure. And some of the clients who had seen my work in the IP sphere, they pushed me to take up areas of the law which I was not so familiar with. I studied it in law school, but that was very theoretical. But the practical application was not something that I had sort of been into. Thankfully, around the 2008, 2009 time, there were a lot of newer emerging areas. So, for example, the Competition Commission of India had just started its regular work in 2009. And the first industry that they targeted was the media and the broadcasting industry. And I was doing some work there. So they said, look, you know about our business, you know what we do, right? And you know what regulatory challenges we are facing. So why don't you use that in, experience and knowledge base to defend us before the Competition Commission of India? And it's a new set of the act. There's no one who's an expert. Jump into it. So I did that. And likewise, when the regulatory aspects of broadcasting and telecoms was just still developing, I got the opportunity to get into that. By the by, I got into other regulatory and other aspects of technology. But the fulcrum or the basis for getting me introduced to all of these was intellectual property. So that remained a constant throughout this. So today, we are a firm of close to 40 lawyers. We have offices in Delhi, Mumbai, Bangalore, and Bhubaneswar. The practice areas that we are engaged in, I've identified the industry sectors of technology, media, telecoms, and thankfully today technology is so blissfully vague and all-encompassing that there is some interface of technology or the other across various sectors. So we are in, e-commerce, we do fintech-related work, we do a lot of work in the digital health space, where we do also contribute in the policy aspect of development of the laws and regulations for the government of India. We do a fair amount of work in the telecoms and satellite communication, so space-based applications, etc. Of course, there is a litigation department, there is an IP protection department. So there are multiple of those. We have 9 partners handling those. So my work is certainly from a management standpoint, along with my CEO, Vartika. We both of us manage the firm. We are responsible for the general business aspects of HR, finance, admin, whatever, right? From a purely legal industry approach point of view, since I am today also the face of the firm, I am mostly responsible for all the business development activities, attending conferences, going and meeting clients, speaking at various occasions, writing articles, etc. And personally, since I'm also a litigator, I like to do a lot of execution. There are very few managing partners that actually engage in day-to-day operational execution. But I don't want to be cut off from that, because that's my recognition as a lawyer. I'll be very happy to delegate work, in which I do, to all my colleagues in the firm. But if I stop being in touch with that, then really speaking, I'm no longer a lawyer and I've just become a business executive, which I don't want to become. So yeah, and then of course to make a decision. For example, the one thing that I want to talk about is there really, from a legal industry point of view, from a developmental point of view, from a firm development point of view, from a revenue model point of view, does it make sense for us to continue to be seen as leaders in the IP sphere? Should we cut down on that? Should we expand other areas? But since IP is so close to my heart, that's something where I also exercise some of the arbitrary and subjective decisions that regardless of whether it pays or not, we're going to stick to it.
That makes sense. And I think IP is a topic that's really becoming a topic of discussion more and more, at least in the corporate circles that I move in, because of companies wanting to go global are wanting to also therefore be mindful, because they're, if not in India, at least their global partners will not appreciate any breach of IPs. So I think I'll take an opportunity to dig deeper on this and ask you, in your experience, what are some laws that are getting inadvertently breached by the marketing companies? Not because they don't want to follow the law, but because I don't think there's enough awareness about laws around what IP and marketing is. So if you could throw some light on that with some examples, that would be awesome.
Sure. So I think, whenever I am asked to give an opinion or a view on a particular aspect, specifically legal liabilities, etc., I try and see what the background or the fundamental or the foundation of that is. So really speaking, if you go into the culture of our country, we've always been a sharing society. Because of course it is always a bottom-up approach, and we grew from the villages to the cities, etc. So there, the emphasis was always not so much on exclusion, excluding others, apart from really speaking, real property. I mean, that's the subject matter of huge disputes between families and friends, etc. But otherwise, in terms of knowledge, we, I think, prided ourselves in sharing that.
True.
So somewhere along the way, there is an inherent conflict between that aspect of sharing and aspect of providing exclusivity, at least on the surface.
Okay.
How IP actually encourages innovation and encourages sharing is that the fundamental premise of IP protection all over the world is that unless you incentivize people to come out and share what they have created, there will always be this nagging doubt in their mind that if I do share it, then will someone else appropriate it? With someone with deeper pockets completely sweep me under the carpet? They will be able to, negate my first mover advantage, etc., etc. So I think over a period of time, that particular perception has gathered some amount of recognition. And even though, and I use these words sort of carefully and with some experience, even though IP laws, amongst others, were kind of imposed upon us by a Western culture, that's the reason why it took time for us to imbibe into what I would refer to as the DNA of the country and the entire environment, acceptance of IP.
Okay, that's a very insightful, deeply thought answer, and I completely agree that as a culture we share. But as a culture, are we not innovative? I mean, maybe I'm going in a slightly mythological direction, but when I hear our mythologies, I feel that there was a lot to our science. We were innovators. We've probably I keep hearing that Hanuman Chalisa has this line which gives you the exact distance between the earth and the sun, and the level of calculation and the level of expertise. So aren't we inherently innovators? And if we are, do we still need this IP protection?
No, we are innovators, and we don't need to go back, into the real, olden times, etc., to try and figure that out. There is this one very interesting word in the Hindi language called jugaad, and that really sort of gives you an indication of what level of inventiveness and entrepreneurship that we have in our country, that we want to resolve issues, however it may happen. So jugaad laga ke karana hai, whatever you want to achieve that solution. So, and you have examples of that, let's say in the villages where if I don't know whether you've seen this contraption, it's like a mix of a rickshaw and some big engine put in, and just to sort of ease transportation issues, etc., including taking the crop to the closest mandi and all that stuff. So I think that as Indians, we are perhaps one of the most creative, and I say, when I say creative, it's not only from a copyright standpoint, it's business standpoint, it's from solution standpoint. It's because, at least till now, I mean, I don't know what the generations in future will sort of, how they will deal with, but there has been a fair amount of adversity that as a nation we've faced from time to time. We faced challenges, we've had to come out with solutions to overcome them.
True.
If today you see, I'm just digressing a bit, but in the entire world community, when you come to technology and cutting edge technology, Israel is really on top there. And the reason why that is because they are that small nation surrounded by countries which are inimical to them, and they are always on the lookout to see as to how they can improve their system, their technology, their infrastructure, in order to be able to just survive more than anything else. So yes, as a nation, we are very creative. As a nation, we have it in us to really come out with product solutions, etc. Should there be that same level of sharing that continues across centuries? I personally think that a case for IP protection gets made out primarily because of the fact that the virtues of the sharing system that existed earlier are no longer there, and specifically in today's world. There are always people on the lookout to, appropriate from you unless you have that protection, and sometimes even after you have that protection. So certainly IP laws are extremely important. But we as a country and as corporates in the country, and therefore marketers in the country, have very little understanding of what IP means, of what all it constitutes, what are the do's and the don'ts of IP. So that's what needs to, I think, so if I can summarize it, unless there is proper education about IP, and not just to marketers, to corporates, etc., but unless it is put in part of the curriculum at maybe the high school level or whatever, we are not going to be IP mindful as a nation, and we're not going to understand what it constitutes.
Okay, valid. I think, very, very small level, it is a topic in a chapter in a subject called laws, business laws, right? So we don't dwell upon it enough. So very valid point. And I think in that sense, I also see people, using Google Images, for example. I've worked with freelancers who say, we'll get the copyright, like the Shutterstock or one of those stock images. And I'm like, no, I don't have budgets. And they'll say, no, don't worry about the budget. We'll just erase the watermark. And I'm like, the whole point of the watermark is that you have to pay for it. But I see that doesn't seem to bother people. So what's your experience around it? Is it okay to use Google Images, to use stock images and just clean it up? Are there really legal repercussions for it?
There are certain subsets to this sort of answer that I'm going to give to you. The first is that the images that are available on Google or certain other platforms are available on the basis of they being licensed to those platforms. And what needs to be understood also is that if I'm a photographer, I would have perhaps clicked 1,000 images before one is what I would select as relevant enough to be put out there in the public domain for it to be licensed or for it to be exploited. So there is a lot of labor that goes into, and of course creativity, that goes into the determination of what will constitute a copyrighted work and something that is possible to even be sold, licensed, or exploited. That person definitely needs to get that person's due for making that investment of time, effort, and money.
True.
So once we understand that if we are removing the watermark or if we are not compensating that person for it, then we are actually stealing. That's when it starts to prick our conscience and impact us morally for us to say, look, no, this is not right. So that's very important as a message to be conveyed, that you are actually going to be stealing someone's work. And it's not enough to say that, oh, I'm not stealing, because let's assume that if it was a car, then I would take it and that person will not be able to use it. Even if I do remove the watermark, even if I do use it, that person can still exploit it. What is the problem? But what they don't realize is that everyone starts saying or doing that, then effectively nothing will be left with the person who seeks to exploit it and who's put in that labor and effort and money and time and expertise. So that's very important as a fundamental concept to understand. The second part is that because it is likely to have been licensed to such platforms, there will be specific terms and conditions of such usage. So for example, if you're using it in editorial sense, right, just to convey a point, or just to give a backdrop to what you're talking about in an article or otherwise, that will be permissible. There too, attribution must be there. You should not remove the watermark. You should say that this is attributed to Google Images on such and such date or whatever, right? But you certainly can't use it for commercial exploitation. Because there are categorization of sub-licenses that these platforms can grant depending upon the nature of usage. And these platforms may not even be entitled to grant a commercial exploitation usage. So that's extremely important to understand. People don't read the fine print. They say it's available. It's available freely, so we can just take it and rip it apart and then use it.
Okay, so in context of social media, because that's my company's domain expertise at Vanilla Skills, that's what we do. We're very mindful of this copyrights. And one of the arguments I often hear from especially new joinees is, if it's up on social media, then it's already in the public domain and we are not commercializing something. We are not monetizing it. We are simply creating a post and putting it up. So it's a fine thing, right? Because end of the day, why are we putting it on social media? Because we hope to bring business because of it. That business will then get commercialized, you'll make profits and so on and so forth. That's my one way of looking at it. But beyond this, is there really, taking a leaf from what you were saying, that, if there is no commercialization of it, then it's okay. So how does this play? Because this is a very fine line. I'm not commercializing by putting up one post.
I agree. So copyright specifically, it's just not one particular right. It's actually a bundle of rights.
Interesting.
So in relation to, let's say, a post that will constitute a literary work, because it's written, typed, whatever.
Right.
Now that literary work, of course, I'm hoping there will be more than just one line. So there would be some amount of substantiality in that literary work that we are talking about, at least right now in this conversation, for it to receive that protection. So once we have determined that it is capable of receiving protection because it's more than a line, etc., it's a paragraph, whatever, then we must know as to what are the rights that the author or owner of that literary work is able to exercise. As I said, there are bundle of rights. There is a right of reproduction. There is a right to issue copies of that work. There is a right to communicate that work to the public. There is a right to make adaptation of that work. There is a right to make translations of that work. There is a right to allow a third party to make a sound recording of that work and to make a cinematograph film of that work. So these are multiple rights that they have.
If I've created a post, I have a bundle of these rights, is what you're saying.
That's correct. And just to sort of give you a more sort of real life example, because one can always argue that is there enough literary material, and I'm not talking about quality, I'm just talking about the quantity of the material. Is there enough literary material in a post for it to even be considered to be copyrightable? That's a different part of the conversation. Here we are making a presumption that it is protectable by copyright. If so, these are the rights that you get. Now, when you use that post as is and literally copy it and paste it onto another of your own reel or your own special social media account, you are reproducing it.
Yeah.
You may or may not make money out of it, but you are impacting that author on owner's right under the statute. And therefore you are infringing that person's copyright. That person may or may not be entitled to damages, but they are certainly entitled to seek a stay order from a court, an injunction from the court to restrain you, to stop you from copying, and also to direct you to delete what you've copied.
Okay. So as you were speaking about this, my one thought was, what about memes? Because the whole premise of memes is that you take a certain structure, change it, contextualize it, and that's how memes go viral, quote unquote, right? So if I can take the Shark Tank example, a lot of memes from that came. Now, being from the industry, I can tell you that sometimes these are perpetuated by the platform or the producer themselves, because they, it's a vehicle to promote the program, right? Now, sometimes it may be so, sometimes it may not even be so.
Right.
How does that impact? Is it okay to make memes? Is that an infringement of someone's copyright?
Something that I also wanted to sort of mention in the previous answer, it's maybe a little more difficult, let's say, to say with regard to a post to determine also the aspect of copyrightability. But let's assume that there is a song, and there are parts of that song, 1 or 2 lines or 3 lines, whatever, that's become specifically very popular. And just to enhance your communication to the outside world on your social media platform, you want to use that as a background. Clearly that song, the sound recording, the literary work, the music, etc., all of it is protected as a copyright. When you are reproducing it, you're clearly infringing. Right? Now, the point is, so the actual infringement is taking place by the user, the person who has that account, right? But there is also a facilitation of that infringement by the platform itself. Our law says, this is also a combined reading of the Copyright Act and the Information Technology Act. The law says that if you are an intermediary, which all social media platforms are, then you're only providing a platform for people to come and put their content, their messages, etc.
Right.
If I, as a copyright owner, notice that my work is being used without permission, without a license, I will write to the intermediary and say, look, this is infringing, take it down.
Right.
If the intermediary acts in accordance with my notice, then the intermediary is protected from liability. But if they don't act and they challenge my rights, etc., which they usually don't, but I'm saying in the event that they do, and I am forced to go to court and seek an order, I could potentially say, look, they're not acting, they're in fact disputing my rights, now please pass an order even against them and make them also liable. So as a result of this, some of the bigger social media entities like Instagram, Facebook, whatever, they say that, look, we want our business model is that we want to attract as many people as possible on our platforms. That's how we generate our revenues, etc. So in order to facilitate that and not continuously be looking to take down content and bother our consumers, etc., we will go and negotiate with these copyright entities and we will take those music licenses. So that there is at least a license that is being taken, then whoever wants to use whatever, they can do it. In fact, recently we've advised a client in relation to this, which it was not an advertisement. It was like a kind of a precursor shoot of videos for an upcoming event where they used a particular song at the background because it was appropriate perhaps as per them to that entire thing. And they received a notice from the copyright owner. But we were able to show with our research to say that, look, that platform already has taken a license. It is available on that platform as a work to be utilized by people.
Got it.
That's fine.
Okay, understood. Okay, so there are fine prints, and my take from all of this is therefore that either read up about it or go to a lawyer. Better to go to a lawyer, because no matter how much you read up, you're not going to read up as much as a lawyer has already read on that subject.
So not only that, it's see, there are the reading up and the content that is available online will tell you what broadly the legal rights and liabilities are. What are the rights? What I just told you, these 5-6 bucket of rights, etc. Is that applicable to your case? That may not be an answer that you'll always find out on the net. So that's why it's always better to have it verified by a lawyer that what you think is correct or not.
Okay. So, taking a leaf from what you were saying, that there's a lot of online material. One of the questions, B2B marketers community, we have a community called the Secrets of a B2B Marketer. It's a WhatsApp community. And one of our community members, Mr. Parag Javale, has asked a question for you. And I'm going to read his question specifically, okay? It says, where can we access IP regulations, and are they specifically demarcated into offline and online content? It's a two-part question.
We may criticize the British for a lot of things that have happened to us perhaps over the years, but the one thing which one marvels at is not only have we inherited that legal system, but also some of the legislation that were framed in the later part of the 1800s has stood the time even today. And the reason for that is the neutrality of the language in its application to the brick and mortar and the digital domain. So there are some developments that have required a special act called the Information Technology Act to be enacted. Because at that time, when evidence was being taken, it was only in documents or orally. Now, right. Whether documents should also be, an electronic document should also be considered a document, could be debated ad nauseum, but the Parliament thought that it's better that we enact a law and specifically say that yes, an electronic record is also a document, subject to you following certain steps to ensure the authenticity of that. So as I said, now there is therefore, to answer the second part of the question, there is no real distinction between what is protectable on the online regime versus what is protectable in the brick and mortar. In fact, even today when I'm advising clients, I always try to bring it into the brick and mortar domain because that's where most of the decisions are, and then apply it to the digital domain. Right? So that's the second part of the question. The first part of the question, is there a place or a repository where one can broadly find out what's happening, what are the laws, etc.? Yes, there are multiple of those. The one which is specific to Indian law is ipindia.gov.in.
Okay.
And that's the repository for it's sort of set up by the Department of Industrial Policy and Promotion, DPIIT now, which is the nodal ministry under Ministry of Commerce for all IP matters. And there are specific heads under trademark, patents, copyright, design. And it provides you a reasonable amount of reading material to find out what the laws are. Internationally also, there is the World Intellectual Property Organization, WIPO, which has a similar repository. And at least the WIPO also has sort of a database of articles and could be applicable to certain fact situations, etc., developments of the law. So yes, those are I would say, two primary sources to start off with.
Okay, thank you. I think what we'll also do is we'll make these links a part of our description in the podcast, so they are easy. I will certainly be reaching out to you for these links so that we've got every alphabet.
Absolutely.
So that's one thing. Another question again from the community that has come our way is, what should be the ideal framework or strategy for a comprehensive IT protection mechanism over a long-term horizon?
So you are looking at this question more from a user's perspective or an owner's perspective?
I think they are asking from a user's perspective, but Praveen Sharma is the person who's asked this. So I will take a liberty on his behalf to say, if you can throw a light on both so that we're kind of covered on both grounds.
So from an owner's perspective, it's very important first to identify what IP is being developed. So if it's an individual, that's an easy question to answer. But when it's an organization, then you do not, unless you have an IP strategy in place, you will not know what's happening. You will keep creating, that may get lost in the system. Even if it does get utilized, it may not get adequately protected within the system or with the assistance of in-house legal counsel or external legal counsel. So it's very important to have a mindset and education about the fact that you are creating IP. Now, IP could be in the form of a brand, a trademark. A brand can be consisting of a word, a logo, a device, combination of numbers, color combination, etc. So that's a wide aspect to be covered there. It could be in the form of a copyrightable subject matter. It could be a literary work, it could be an artistic work, it could be a dramatic work, it could be a cinematograph film, sound recording, etc. It could also be a patentable invention. So there's some, you don't have to, need not be rocket science, but it can be perhaps also an improvement upon what is already out in the existing in the public domain. Giving you a very crude example, the first time that someone perhaps would have made a chair, they would have had something to sit on, something to support your back with, and something which would then hold it to the ground. Possibly your armrests may not have come about at that point in time, right? But when people realize that their arms are hanging loose on the side of the chair, maybe they would have thought of, let's look at creating armrests, so that your arms can also rest upon them. That did not require creation of a new chair. It just required the addition of something which would add further value to it, and which the person who created the first chair with just the stand and the backrest could not contemplate. So these are even these sort of, now in today's context, of course, we've moved way ahead in technology, but and mechanics, etc. But I'm just giving you an example of how patent system works. So it could be a patent.
Yeah.
It could be a design. I have a computer screen. Now, computer screen with its width, its dimensions, etc., what is available to be placed on the desk, etc., will provide a lot of utilitarian aspects to it. They are all useful, right? Yeah. But the design of the computer screen itself, which has nothing to do with how useful it is, it's just aesthetics, something that appeals to the eye, right? Yeah. That is something which is protectable by design. So very often people don't realize what is the extent of IP that they are creating or is capable of being protected.
Okay.
It's important to have that.
I have a question here. So if somebody has a model, like the framework model, if it's a marketing model, for example, right. The 4Ps is the most famous marketing model there is out there in the space of marketing, right? Product, price, place, promotion. Now, this is an established model. Probably somebody owns an IP to it. If somebody turns that 4P and says, I have a 6P model, and the 4Ps of those 6Ps are the same as the previous model, and then they've added 2 more, can this new model therefore also be IP?
Okay, so this is where different jurisdictions have different approaches to IP. So for lack of a better terminology, this is actually a business method. I'm advocating that the 4Ps are an essential marketing tool or strategy for you to be able to realize whatever you're trying to achieve, right? And I have done that on the basis of whatever my experiences have been in the market, etc., statistics, research, etc. And I've come out with a defined piece, which if you follow, you'll be able to achieve what you want to achieve. This is a business method.
Yeah.
Business methods are not patentable in India. But business methods are capable of protection in the US.
Okay, interesting.
As patented inventions, right? Now, what happens is that, and that's a conscious policy decision that country has taken, the US or India or anywhere else in the world, that they are going to protect business methods or not. Because at the end of the day, you must realize that because the laws on IP want to foster the availability of competition, of knowledge in the domain, so more people are able to imbibe that early knowledge and create something afresh. Example that you gave from 4P to 6P. That's the whole purpose of protecting IP. But to what extent should you do it? Is there something that you are foreclosing or stopping development of creativity if you give too much monopoly to a particular part? So in India, we feel that business methods are too inchoate, they're too undefinable for them to receive patent protection. But if you don't have patent protection, then is there something that you can protect this by at all? One is that you write out your entire project or your business method, etc. And once you write it out, it becomes subject matter of copyright. Now, the point is you get copyright, however, only in the manner in which you've written it. So if I read that and I am able to not paraphrase it, but I'm able to come out with an alternative solution using the same concept or the idea, I can't be stopped from implementing it. As long as I've not copied your literary work. So the protection is very thin. It's a very thin level of protection there.
Okay. So while it's clever, it's not a very hefty one. Got your point. I think from all this, my belief is reiterated that it's good to know the laws. It's important to at least have an understanding of the laws in context of the work that one does. But when it comes to these finer details, that is where one has to turn to a lawyer, seek a professional help, and not try and just wing it. How?
No, I agree. And likewise, for example, you mentioned, for example, social media presence.
Right.
Now, as a lawyer, I think I've written an article. I get my IT guide just to put it on LinkedIn and say, "Acha, LinkedIn pe aa gaya now." People will read it, people will see it, etc. But that's not a strategy. It's an ad hoc solution, right? If I want someone to really tell me that, I want to achieve this outreach to this audience, what should I do in order to be able to do that? This is what I'm doing. Am I doing it correctly? Now that can only come from a specialist, someone who has the experience, someone who has the expertise. Likewise for a lawyer.
Okay, very well put. And I think it's a good analogy to give. It's a very quid pro quo kind of analogy. The very name of my show is Secrets of a B2B Marketer. So this is a question we ask every guest. Tell us a secret, but in your case, I'm going to ask you, tell us a secret which you think every marketer should know in context of law, of course, but possibly very few do.
The secret really is that, and there's not just one, there are many of those, but I can just possibly try and give you one or two. There is a perception amongst a lot of people that when you are using someone else's work, photograph, sound recording, music, etc., and especially in the case of music, sound recording, films, if you take 10 seconds, it's fine. If you take 30 seconds, it's fine. Because, you're not taking the entire work. Right? But that's incorrect. And that unfortunately often leads to a lot of complications and issues of infringement that people can clearly avoid. I don't know whether you've heard this. I'm sure you have heard this song called Pretty Woman. Right? So the opening bars of that, of that song, that entire thing is only about 10-15 odd seconds.
Right.
But this case was litigated up at the Supreme Court, and the Supreme Court said, look, that opening part is the most recognizable part of the song.
Right.
You may have transitioned after that opening part into something completely different, but I'm sorry, you can't. That's substantial taking, because the copying is not just about quantitatively how much you're taking. It's also qualitatively, are you taking the heart of the work?
So
that's something that people need to be mindful of, that it is not just 10, 15, 20, 30 seconds. However, there is this concept of what is known as a de minimis use. It's so minimal that even though it is an infringement, the courts will say it's not worth our time to actually adjudicate this particular issue. But that's as little as maybe 2 or 3 seconds. I'm just giving you a broad this thing, but typically it's irrelevant to the entire context in which you're using, then it'll be deemed to be de minimis. The other secret is that when you are looking at utilizing a copyrighted or an IP protected work, it's not a legal advice, it's more just general. Very often, please ask yourself a question intuitively and from your gut. Is this taken from someone else's work? If you had been in that person's place, would you have also treated this as a stealing or as a taking away? Most often the answer will be yes, and at that point in time, you know that you're doing something wrong. So I think that that's the time that you need to figure out what you want to do. Are you willing to take that risk, or would you rather protect your interest?
I often say that my conscience is extremely naughty. It won't let me sleep. It elbows me. And I love my sleep too much. So if I'm going to lose a bit of sleep over something, then
it's not worth it.
Yeah, it's just not. I don't care what the law says about it. I'm not doing it. And so one of the examples I can share here is that a lot of times we have non-disclosure agreements because we manage the social media accounts of people, right? Now, the senior management person will not want the world to know that the account is being managed by a third party.
Correct.
So more often than not, there's a non-disclosure agreement. But even if we don't have it signed, if there's no paperwork around it, I think it's just basic courtesy to that person to not give that name out. So law notwithstanding, one should also look at what's ethically right in these kind of context. And if it's stealing, then taking a leaf from that 10-second example you give, then whether you're stealing 10 seconds or you're stealing 3 minutes, you're still stealing. And do you really want to steal? It all boils.
And just to give that sort of further context to it, whenever the law has developed all across the world, it has always drawn from ethics and morals. So just the example that you gave, one of the most celebrated cases on misappropriation of confidential information actually had a situation when there was no NDA.
Okay.
And the court said that if the person who's making the disclosure and the person who's receiving that information, if this exchange of information happens in circumstances where an ordinary, reasonable person would presume that such a disclosure has been made confidentially, then that's enough. If you have an NDA in place, it just helps you in the process of shifting the burden of proof to the other side to say that there was no confidential engagement in place. But in law, if I disclose to you something which I have also mentioned that this is my work and I have not taken it to anyone else, etc., and why don't you evaluate it for your purpose, I would not disclose it to you if I thought that you were going to share it with anyone or exploit it yourselves.
Right.
So the conditions of confidentiality will be presumed from that.
Okay, lovely. So these are two very good secrets that you've shared. I think all in all, the whole show has been so insightful. My God, just to recap everything so that we don't forget. One is, and this may not be in chronological order, but I think for us, the first thing we spoke about was in context of the experiences in terms of how people are breaching laws, right? Copyrights in particular, where it's assumed that because it's in the public domain, it's free for everybody to use. You can just take a piece of it. So A, that's not true. B, any of such work needs to come from the questioning of, am I taking away someone's work and therefore stopping their opportunity of monetizing it? There are further, of course, finer details, like you said, whether it's for commercial use, not for commercial use, which is where a lawyer can probably guide someone. You also shared a resource with us. If you could please repeat the resource name where one can go and read up about the copyrights or any of the laws.
So I will, if you would like, I can send it to you on the chat box as well. It is ipindiaonline.gov.in.
Okay.
IP India is easy. Online.gov.in.
Perfect.
And the other one is wipo.int. INT for international. So wipo.int.
Okay, lovely. So we've got that. We've also got you sharing about some secrets, whether it is 10 seconds, 30 seconds, or 3 minutes. Stealing is stealing. So be careful if you're taking something from there. The only exception that I understood was that sometimes the platforms would have purchased the licenses. If I can contextualize it for our listeners, on Instagram, you find these musics that you can add to Reels. Clearly, these have been licensed from the creators, and that's why you're able to use them, which is why sometimes you find some songs, sometimes you don't find some songs. So, and Instagram is just an example. YouTube also has something similar. I'm sure TikTok is banned in India, but overseas, I think TikTok also has some such arrangements. So that's the other takeaway that we have. Have I missed anything? Do you think there was something else that
No, I think just in terms of the understanding of IP and the fact that it is an education that you need to possibly invest in to try and find out what IPs are, what the rights are, what are the do's and don'ts, and whether you're an owner or a user, have an IP policy stroke strategy in place. Because very often, even though an individual employee may choose to do X, Y, or Z, the company should not be liable if it has a system or a policy in place saying that the terms and conditions of engagement of all the people are that they should not breach anyone else's IP. And look, I as an entity, as a company, was not aware that this individual was doing this.
Right. Okay, that's a good point. Thank you for sharing all of this. I think these last few minutes, more than 30 now, close to 45 minutes, I believe, have passed very quickly for us. It was very, very insightful. And I loved that you shared these finer details, which I think most of us don't invest our time in. So thank you so much for making time to be on this show.
Thank you so much for the opportunity. I really enjoyed myself.